So welcome everyone to this evening's constitutional conversation with our guest, Peter Berkowitz. Peter is an old friend of mine, I guess, 10 or 15, maybe even 20 years now. He is a political theorist who has taught government at Harvard and taught at the Nino Scalia Law School, and now is a senior fellow at the Hoover Institution here at Stanford, although mostly ensconced in the Hoover offices in DC. But this quarter, he is teaching a course in the university, in the college, on varieties of conservative political thought, which is a course I'd kind of like to take. I didn't know we had so much variety, but in any event, welcome, Peter. And he's going to be talking this evening about common good constitutionalism, which is, I suspect many of you in the room know even better than I, has been quite the rage in some circles in the last several years. So please, and for any of you who are not familiar with the format here, Peter will be talking for 20 minutes, half an hour or so, and leaving plenty of time for questions and discussion afterwards. We have about, I guess, 2 or 3 times as many folks attending via Zoom as we have in this room, and some of them will be asking questions too. I guess, Morgan, you'll be curating the questions from the Zoomers, right? And then people here and actually physically here can fend for yourselves. So please join me in welcoming Peter Berkowitz.
Thank you very much. Well, it's good to see you all here at Stanford Law School. Thank you, Michael, for the introduction. Greetings to those on Zoom. Common good constitutionalism. Before we get to the heart of the matter, or to get to the heart of the matter, I thought it might be useful to mention 2 possible understandings of the aim of constitutional government in America. One possible understanding, let's call this, I don't mean to be tendentious, let's call this Madisonian constitutionalism. Says that the chief purpose of politics is to create the conditions under which individuals, families, and their communities can pursue happiness as they understand it. One view. And let's call the other, let's call it common good constitutionalism. The aim of American constitutional government, as all good government, is to promote virtue in the citizenry. There can be overlap between these 2 views. For example, the Madisonian view presupposes a virtuous citizenry, presupposes different sets of virtues in different constitutional offices. But it doesn't make the promotion of virtue the highest and the guiding task. Common good constitutionalism does. I should say initially 2. A constitutionalism that is a common good constitutionalism needn't make virtue the chief job of government. How do I mean? Well, there are actually a variety of opinions about what the common good is. Does Madisonian constitutionalism have an opinion about the common good? It seems to me that it does. What's that opinion? The good that we can share politically is the creation of a system of political institutions that effectively preserves our constitutional rights, which themselves are designed to instantiate our unalienable rights. That's a good we can share politically. It's certainly not the highest good for a human being. But what goes under the name of constitutional conservatism, it seems to me, often confuses the common good with the highest good. I'll have more to say about that. I'm going to speak specifically about a book that has received a lot of attention as the leading statement of common good constitutionalism. I think the book is called Common Good Constitutionalism by, strangely enough, by Professor Adrian Vermeule, an expert on, among other things, administrative law at Harvard Law School. What is common good constitutionalism as Professor Vermeule understands it? Well, a couple principal theses. One thesis is that what Vermeule calls the classical legal tradition is the fundamental matrix within which American constitutional government was formed. What is the classical legal tradition? The classical legal tradition is an amalgam: Roman law, canon law, natural law. This is a real tradition. That's not controversial. It is, to say the least, controversial to assert that it is the fundamental matrix in which American constitutional law was not only formed, but continued to operate until 50, 60, 70 years ago. Second, what does this classical legal tradition teach? Vermeule says that its master principle, and ours should be today, that, now I quote, all public officials have a duty and corresponding authority to promote the common good. Now, that can be treated as either a mundane statement. What else would public officials do in Madisonian constitutional order? All the public officials have an interest in and an obligation to help secure a political system in which our rights are protected. Those rights, of course, create a broad framework in which we can engage in democratic politics. But that's not what Vermeule means. In fact, for him, such a constitutional system seems to be at least in tension with what he means by the common good. Rather consistently, Vermeule suggests that a common good constitutionalism is a constitutionalism that is devoted to promoting the highest good for a human being, virtue. Now, to suggest that all public officials have a duty and a corresponding authority to promote the highest virtues in citizenry seems to me creates serious problems for the American constitutional, from the point of view of Madisonian constitutionalism. Indeed, it actually calls into question the first claim, that the fundamental matrix in which American constitutional government was conceived was the classical legal tradition. Indeed, as I see it, Vermeule's theory and his reconstruction has the perverse consequence of reading James Madison out of the American constitutional tradition, and also Thomas Jefferson. That said, there are definite important contributions that Vermeule's book makes. I want to mention a couple. I'll come back to the problems. I should say, one of the curiosities of the book is that while it's called Common Good Constitutionalism, Vermeule himself actually operates not in the field coming from not only law but political science that I would call constitutionalism, but he really operates in the world of constitutional theory. His principal interlocutors in this book are the Living Constitution School of Constitutional Jurisprudence, the Progressives, and the Conservatives, the Originalists. In fact, his most extended interlocutor is Ronald Dworkin. And he makes an excellent point about both progressive approaches to constitutional jurisprudence and conservative approaches, originalism. Both rely on conceptions of justice and human nature that they are embarrassed to or unable to acknowledge. Progressives speak of a living constitution that changes as the time changes, and somehow the constitution is always corresponding to a progressive understanding of what morality requires, and judges are authorized to strike down legislation on the basis of that evolving understanding. More consistent with Ronald Dworkin, Vermeule says, no, that's not what really is happening. Progressive scholars, judges, justices have an underlying conception of human nature, an underlying conception of justice, and that it is to that which they appeal. He claims as well, in some of actually his most, his angriest passages, that conservative scholars, originalists, who claim to base their jurisprudential reading on, let's say, the public meaning of constitutional language at the time of ratification, cannot but help but have recourse in interpreting the grander and vaguer formulations in the Constitution, subsequently in the 14th Amendment. They can't but have recourse to opinions about human nature, opinions about justice that are not determined by the public meaning of constitutional provisions. And I think he does an impressive job of bringing into focus some of these difficulties for both living constitutionalism and originalism. And second, it has to be said that his account of the classical, that in giving us an account of the classical legal tradition, he confers upon us a benefit, because I think it is true that relatively few scholars of the law these days, people who teach in law schools, have had training in the classical legal tradition, know what it stands for, appreciate its implications. And even if, as I do, you disagree with his claim that it's the fundamental matrix of American, it has been the fundamental matrix of American constitutional law. If you've learned from Aristotle, as I have, that all serious study of politics, and therefore all serious study of law, is also comparative study of law. That doesn't just mean horizontally your own time, vertically other times. Coming to appreciate the teachings of the classical legal tradition, especially how it differs from Madisonian constitutionalism, can be instructive, can enrich our understanding. So those are important contributions. But there are problems with common good constitutionalism. For one thing, I think Vermeule's account of the classical legal tradition misunderstands the deepest strands of that classical tradition. Going back to Aristotle. And by the way, glad to talk about it. It's a misunderstanding he shares with a writer of another book that along the same lines. The book is called Why Liberalism Failed, ? By Patrick Deneen. And the mistake is this. It's to suppose that the older way of thinking, the pre-modern way of thinking, the classical way of thinking, teaches that all political actors are engaged in the promotion of virtue. All political regimes are engaged, all decent regimes are engaged in the promotion of the highest virtues. It's true that in Aristotle's thinking, in Aristotle's politics, the best regime is articulated as a standard to judge actual regimes. But Aristotle assumes that it is highly unlikely that any of us will live in the best regime. something you could wish for, you could pray for, that prayer or wish is unlikely to be realized. So he also distinguishes the best practicable regime you could hope for, and more importantly, the regimes you actually live in. The best practicable regime is actually not oriented toward virtue. Aristotle calls it polity. It's a mix of oligarchy and democracy, the rule of the few who tend to be wealthy, and the rule of the many, the people who tend not to be wealthy. And Aristotle argues that in those regimes, you have to understand the principles or the mix of principles that actually orient them, and the laws should be made relative to those principles in light of the highest good, maybe. The implications are that for a regime such as ours, the laws need to be made relative to the regime's fundamental goals. And near as I can tell, the fundamental goal of Madisonian constitutionalism is not promoting virtue, I'll come back to this, but securing freedom through individual rights. One problem, a misunderstanding of the classical tradition. Second, as I've already suggested, common good constitutionalism, at least Vermeule's version of it, puts forward a highly misleading understanding of that fundamental matrix of American constitutional government. Vermeule insists on its continuity, the American constitutional regime, with the ways of thinking about law and politics that go back thousands of years. Almost thousands of years, more than 1,000 years. That's not how the founders understood it. I don't deny that you can find some cases in which judges, especially early on, and still today, appeal to justice, a notion of justice that is not elaborated in the Constitution. Of course, that's true. But Alexander Hamilton certainly did not stress the continuities of the American constitutional tradition with 1,700-year or 2,000-year tradition, right? You remember from, let's say, Federalist Number 1, echoing John Locke from 100 years before. Hamilton says, announcing a break with all previous tradition, it's been left to our generation to decide whether government can be established from reason and choice, or whether it's always a result of accident and force. Not a lot of authority in the classical legal tradition for that view, and in any case, Hamilton thought this to be a novelty in human experience. Moreover, in Federalist 9, as you know, Hamilton says that the new Constitution, one that's gone out to the people for ratification, by the way, there's not much of that in the classical legal tradition. It's gone out to the people in the various states for ratification. Hamilton says that this Constitution is based on a science of politics that, like most other sciences, has received great improvement. It's based on a new science of politics. Now, there are continuities with the old science of politics, but Hamilton is at pains to emphasize the new science of politics, the innovations. As you know, in Federalist Number 45, Madison explains, of course, they're all writing under the pseudonym Publius. Madison emphasizes that in this Constitution, the federal government is a government of few and defined powers. State governments are governments of numerous and indefinite powers. If you look at Madison's enumeration of those few and defined powers, war and peace, commerce, taxation, there's not a lot of room for promoting the common good understood as our highest virtues as human beings, as social and political animals. I could go on, but you get the idea. Also, I only have 20 or 25 minutes, and I want to leave room for questions. So a second problem is that the first problem is a misunderstanding of the deepest strands of the classical tradition. A second is that this account of our Constitution, common good constitutionalism, ignores or suppresses, when it simply doesn't express strong distaste for those dimensions of the American Constitution which are devoted to securing individual rights, which, in my judgment, are among the deepest strands. This brings us to what seems to motivate the book, a certain loathing of the classical legal tradition, which unites this book, Common Good Constitutionalism, with other strands in contemporary conservative thought. I've already mentioned Deneen's thought. I should mention Yoram Hazony's recent writings, including his new book out next month called Conservatism, a Rediscovery. One mistake all these books make is to associate liberalism, the modern tradition of freedom, with the very contemporary, what Romeo calls liberationist project. Liberationist project is something he associates especially with living constitution jurisprudence, progressive jurisprudence. What is the liberationist project? This is the aim of using government to emancipate us all from the constraints of custom, tradition, inherited beliefs, practices, and associations. In my judgment, there's a lot to be opposed to there. And Deneen shares this view, and Yoram Hazony shares this view. But the mistake is to equate Madisonian constitutionalism with this liberationist project. As I suggested, it should be properly understood at the very beginning. The Madisonian view, consistent with the vision of government laid out in the Declaration of Independence, is that government creates a framework in which individuals and communities can pursue their conception of good. Actually, a government that's devoted to emancipating individuals from custom and tradition is a government that would, from the Madisonian point of view, be exercising entirely illegitimate coercive powers on individuals. I could go on, but I should conclude, and I will. How should we think about this matter? The common good constitutionalism, I think, does have this salutary benefit. It does bring into our conversation classical ideas, not least Aristotle. But I'm reminded of a wonderful remark a former colleague of mine, Harvey Mansfield, made to an undergraduate one year. We used to teach a course together on the history of political philosophy, ancient and modern, ancient medieval during the fall, modern during the spring. And at the end of the class, it's Mansfield's turn for the last day of class, and a particularly precocious student, which is the kind of student Mr. Mansfield especially liked, that, well, Mr. Mansfield, all year you and Professor Berkowitz have been presenting different thinkers, and you seem to enjoy and express admiration for each and every one, but they offer us different opinions. I'm just wondering, whom do you prefer? Mansfield paused for a moment, and then he said, a vintage Mansfield statement: Locke in the short run, Aristotle in the long run. I'd be happy to elaborate on that and other opinions I've expressed during the questions. Thank you.
Just a moment to say, anyone who's online, I hope you can hear me through the speakers in the ceiling. And please do post your questions on the chat on Zoom, and I will ask them for you. And anyone who's in the room, please try to speak loudly enough so that your voice can carry through the speakers and the folks online can hear. As you can see, the green lights illuminate where the speakers are. So very high tech in this room. Okay, one of the benefits of COVID. So we can do this pretty organically if you'd like, but otherwise I'll just call on folks with their hands raised if you guys don't jump in naturally. So go for it. Ask a question. I will cold call the undergrads if need be. I see you. I'm just
The fellow in the maroon sweater has a question.
So do you have a theory why this idea of Vermeule's and his friends is taking off at this particular convention?
Yes. But I will repeat some remarks that Lindsay over there has heard, who sat in on the class a little while ago. I could make it a little bit longer now. I think young conservatives are very angry. They see a great deal of disorder in the United States, and they want to do something. And national conservatism and constitutional conservatism says, you've been failed by generation or generations of conservatives. Here's a program, and it involves doing a lot, overturning how everything has been done for the last 50 or 60 or 70 years. There's a lot of work to be done. And you all, you young, fresh people who are not corrupted by what some people call conservatism incorporated, are just the ones to join me in this this transformative activity. It's not put as transformative, it's put in the language of recovering and restoring. That seems to me plays to the well-known tendency of young people with high and idealistic aspirations to do something. Whereas the message, what was the message of William F. Buckley? To stand athwart history and yell, stop. How do you rouse people, rally people to say, stop, do nothing? Having said that, and as we happened to discuss earlier this afternoon, it turns out that Vermeule is arguing in a long line of American conservatives. What we call American conservative, the American conservative movement crystallizes in the post-World War II era. And there are any number of social conservatives, traditionalists in the late 1940s and 1950s who are arguing that we face disastrous decadence in the United States. The moral order is disintegrating. What was then called liberalism, what we today call progressivism, sometimes wokeism, woke progressivism, but then liberalism has captured our universities, has captured the bureaucracy, and we need to take dramatic steps in order to recover ancestral moral wisdom. So, actually, for me now. I don't mean to take away originality from Adrian Vermeule. I know of nobody who wrote a book trying to recover specifically the classical legal tradition, related it to contemporary jurisprudential debates, or argued that the fundamental matrix of American constitutional government is the classical legal tradition. But the idea that that the larger idea that we need a polity that is devoted to the promotion of virtue is an idea that was promulgated by conservatives, some traditionalists in the 1950s and 1960s, who, by the way, similarly didn't simply want to say stop to history. They wanted to transform the country.
What implications do the two political theory mistakes have for the conversation about legal interpretation? Where does your kind of critique, does it get us any headway on his critique of living constitutionalism?
Yeah, I think the original part is the critique of originalism. There are any number of scholars of constitutional law who have been critics of living constitution jurisprudence. So I guess I don't need to go into detail there. Just to say that seems to me it's quite dangerous to have justices unmoored from text, history, structure, and precedent, who believe that they are authorized to judge in light of what they think is best for us at this particular moment. And Vermeule is well aware, though, of the triumphs of originalism, the extent to which progressives these days attempt to do their best to anchor progressive interpretations in the Constitution. His more searing criticisms are of originalism. And there, he sort of equivocates. On the one hand, says that his version of jurisprudence is common good constitutionalism, and it's the right view. We should be common good constitutionalists. We shouldn't be originalists. But he also makes this argument. Originalists are common good constitutionalists. They just don't realize it. But does that mean originalists are trying to promote virtue? And here he's not quite explicit, but this at least is how I read it. No. Originalists also, to a very significant extent, when they're trying to determine the public meaning of the original public meaning of constitutional text, they are incorporating into their understanding public meanings that go beyond constitutional text and structure to include opinions about justice and the purpose of government and human nature associated with the Constitution. I think that's a good thing, and they should do that. Now, they should do it more explicitly. Understand this matrix, and we have one of the nation's leading experts on these matters, and Professor McConnell could speak to this, and I can't say that in every respect Vermeule's been fair to the complexities of originalism, but there is this equivocation. Sometimes he says they're not common good constitutionalists. Sometimes he said they're common good constitutionalists too. They just don't realize it. So my own view is that it's actually the criticism that says they're common good constitutionalists but don't realize it is actually more illuminating. In other words, what we really have here is a contest between two conceptions of the common good. One says, for a variety of reasons which we could discuss, the job of government under the US Constitution is to secure individual rights. There are a variety of ancillary undertakings that government should engage in to secure those rights. That's a conception of the common good, which says the common good, the common political good, is not the highest good for a human being. We'll leave that up to citizens to figure out. The other conception of the common good, the one that Vermeule pushes, is that the common good is the highest good for a human being. And public officials, also judges, keep that in mind. Now, Vermeule qualifies this in a variety of ways. So I think, and I hope I'm not inaccurately simplifying, he means something like this when it goes to jurisprudence. This answer is a bit long-winded, but I learned this in law school. Class I took on legal reasoning from Justice Aaron Barak, then president of the Israeli Supreme Court. I think what he said of Israel is true of the United States. He said this is in a way a Dworkinian point. He said, Supreme Court justices face, at the end of the day, three kinds of cases. Easy cases. That's 75% of the cases we confront. In Israel, they have much bigger docket than our Supreme Court justices, who the easy cases are winnowed out. But in Israel, I said, as a appellate court judge, 75% of my cases are easy cases, meaning as soon as I hear the facts, I and my clerks know what the right legal answer is. You may have heard that law is radically indeterminate. It's not. In most of the cases we know, judges know. Or actually, most of the cases never even get to court because lawyers say, you got no case. All right. 75% are easy cases. 20% of the cases are of intermediate level difficulty, meaning, just as Barak would explain, my clerks and I would read the briefs, we'd listen to the arguments, we'd meet in chambers, and we wouldn't be sure. Then clerks would go out and look at the case, look further into the law. I'd go out, delve further into the law. We'd reconvene in a week, and we agreed on the right answer. Intermediate level because it required some work to get the right answer. There was a right answer under the law. We were convinced. That's 95% of the cases. But 5% of the cases were hard cases. We read the briefs, we heard the arguments, we weren't sure. The clerks went out to study, I went out to study. We came back in a week and said, you know, there are ambiguities in the law, there are gaps in the law. This is a case that these circumstances really were not anticipated by the law. What do we do now? Well, famously, Ronald Dworkin has an answer. What's Dworkin's answer? We resolve the case in light of our best understanding of the requirements of freedom and equality. Now I add some words to Dworkin, progressively understood. Okay? But only in the hard cases. Vermeule says something like this, not in as simple-minded a fashion as I'm presenting it, but something like this. But in those hard cases, I think Vermeule's charge to the judges, not in the easy cases, not in the intermediate level cases, but in the hard cases, charge to the judges is, to the extent possible, promote the highest human virtues, the good for human beings in political community. That's different from Dworkin, and I think it's different from Madisonian constitutionalism. If we take the entire framework and the spirit of the Constitution and the spirit of the laws. So, it's a long-winded way of saying, promote virtue in hard cases. That's the jurisprudential bottom line.
So, why doesn't Adrian Vermeule call his book Human Good Constitutionalism? It seems that, and you put your finger on exactly the problem, I think almost everybody's going to agree that government must produce, must protect, must advance some good, even if that good is at a lower level than your protection of rights. You would have to be at least protecting the good of some kind of common security, and at least the ability to have some kind of welfare that was less than collective and impoverished. What it seems that Vermeule wants to do is go to this very strong Aristotelian conception that there is a human good. Indeed, if you're going to go back to Aristotle, and also back to Plato, when he says the good, we just think there is just one unitary metaphysical conception. But I take it as that you might right to say that that's your word. Is that what Vermeule is doing is sort of taking a notion that a lot of people are going to agree with. Common good is an important role of government, but he's then adding to it, this conception that the common good is the unitary, singular human good that is basically in their killing form of perfection.
Quick interruption, Peter. We have a question from Zoom. Could you just recap the questions that our audience members are asking so they can best hear the question? Thank you so much.
Sure, although it's going to be a challenge to recap, Professor Overs. So I will do my best, but I will apologize in advance. I won't be able to recapture all the complexity. The question was, why didn't Adrian Vermeule call his book Human Good Constitutionalism? Aren't I implying that's what it's really about? And wouldn't that more accurately reflect a classical view that we see in Aristotle and indeed in Plato, where the aim of the regime actually is to promote the best life? So I'm going to refrain now from speculating on Professor Vermeule's motivations, but I will speak to the consequences. Calling it common good constitutionalism obscures what's actually going on. One, I mean, even calling it human good constitutionalism would be a kind of obscuring. It's really promoting virtue constitutionalism. That would capture it most accurately. If I recall that, lots more people than are doing so right now might object to it. But there's another point I want to make. I actually don't think, though, he does actually, his approach reflects what somebody who had gone to school with Plato and Aristotle would be championing today. We can start with Plato. Plato didn't imagine that democracies could be tutored to promote the virtues. He certainly believed that democracies contain seeds of their own destruction. And he mostly has an account, and as you know better than I, in the Republic, of how each regime, as a result of the seeds of its own destruction, comes deteriorate. But there's no suggestion that democracies can be taught to be promoters of virtue. But when we turn to Aristotle, student Aristotle, by the way, there's also no suggestion that democracies can be taught to promote virtue. There is a suggestion, though, in a kind of regime you could reasonably hope to live under, a mixture of oligarchy and democracy, a mixture of people having power, the majority having power, and the few wealthier people having power, sharing power, as it were. There is an idea that through education, the citizenry can acquire those virtues that are necessary to counteract the regime's worst tendencies, but not the virtues of human flourishing. The equivalent today would be something like the equivalent today would be, I suppose, can our families and can our communities and can our schools teach the most basic virtues that enable us to maintain free institutions? Now, there never was a suggestion in Madisonian Constitution, at least of which I'm aware, that those virtues are equivalent to the highest virtues. But I guess that's my point. The classical tradition in its broadest doesn't argue that in whatever kind of regime you happen to live, public officials should be engaged in the business of promoting the highest good for a human being. They should be operating relative to that regime. And our regime is defined by two features, three depending on how you count. One, our regime assumes that human beings are by nature free and equal. Our regime is in the first place devoted to securing individual rights, and our regime sees legitimate power as deriving from the consent of the governed. Our virtues, our thinking about what public officials should do, from an Aristotelian point of view, should be relative to those notions, which are, seems to me, the most fundamental notions which our regime rests.
I'm going to put a question to you from our Zoom audience. Someone asks if you could explain the method for line drawing among the three types of cases that you mentioned, going back to your earlier remarks about easy, intermediate, and hard cases.
Oh, I meant that as illustrative. I have no sharp theoretical distinction. As it was taught to me by Justice Barak, it was, the line is what judges and their clerks think they know at different stages of deliberation. You see some cases and judges, and by the way, I'm not speaking about intuition. I'm not speaking about, who was it that says, I know pornography when I see it? Was that Justice Douglas? Justice Stewart. It's saying a judge with much experience in legal matters says in many of the cases, there's no controversy or there's no complexity here. As a result of my years of legal training, it's clear that they're the winner or they're the winner. Some cases there's just simply the actual experience of not knowing the answer without study and then acquiring it through study. It depends on the case, depends on the body of law, depends on the circumstances. And then the experience of thoroughly studying the facts, thoroughly studying the law, and seeing their gaps, their ambiguities, there's imprecision in the law. It's a new development, which the law doesn't seem to have anticipated. Well, how do we apply an enduring principle to a new circumstance? And we haven't got an easy answer to it. So, but I haven't got an algorithm to distinguish those three. Please.
Yeah, so in Vermeule's book, right, there's certainly a sense in which he's trying to appeal to a certain classical tradition or understanding of natural law. I guess my question to you is whether or not you think there's still a way, because obviously Locke is operating within a certain tradition of natural law. Is there a proper understanding or role of natural law within the understanding of the American founding that might potentially allow us to reconcile some of the aims or goals that at least Vermeule is trying to accomplish by bringing this in?
First, you tell me what those principal aims or goals are.
Well, that's a good.
That's a good question. Okay, he says to make coherence out of our of the story of constitutional jurisprudence in the spirit of Dworkin's chain novel. Yes, I've already suggested. So, but I'll go back for a moment. We could have a discussion about natural law, its tradition, what it entails. We would probably want to have a discussion too about natural rights, which represent a break with the natural law tradition. Law also speaks about the law of nature, which is different from the natural law tradition. This is probably not the place to go into them. But we can say the following about the natural law tradition and Locke on the law of nature and natural rights, inalienable rights, human rights. These are different ways of speaking about justice. The tension between law and justice is as old as law and justice. At the very beginning of his book, Vermeule says, and actually this idea developed, as far as I know, most profoundly in a dialogue some people think was actually by Plato. Minos, do you know, is that accepted as?
Usually accepted, yeah.
Usually accepted, which raises the question, what is law? Vermeule says in the classical legal tradition, law is actually part of justice, is a conceptually a part of justice. In the American legal tradition, we tend to distinguish them, especially positivists. Law is what is duly enacted by human beings, and justice is a standard that above it. We can say of a law it's just or unjust, but it's still law. Vermeil says, no, that's a bad way to think about it. Law, properly understood, as the classical legal tradition understood it. On that conception of law, an element of law itself is its justness. And so he wants to break down that distinction, which has the consequences for judges of always inviting them, even in cases that are not so hard, those 5% of cases, to base their decisions on what they regard as promoting virtue. So I have sympathy for the view, and I think one can show in a lot of cases, and Vermeil does this actually in a lot of cases, especially most dramatically Lochner, how the judicial reasoning calls upon, he wants to say inevitably calls upon, understandings of human nature, understandings of justice. So we can learn from that. But here's something I think he doesn't quite appreciate. You can read the book from beginning to end and get no sense that the content of the common good or justice is a controversial matter. Now, this was crucial to Aristotle's understanding of politics. We are creatures. We're social and political animals, Aristotle says at the beginning of politics. We speak, and what do we speak about? Good and bad, and just and unjust. We disagree about them. We're not distinguished by our possession of knowledge of justice, but by our disagreements over them. Even more so in the United States of America, a multi-religious, multi-ethnic, small R republic, transcontinental in size, gigantic in its for its time in the 18th century, gigantic now. As I understand it, Madisonian constitutionalism begins from an appreciation that there is controversy among Americans, among the various Protestant sects and a few other religious faiths, about what God wants from us and how we should live our lives. For that reason, it's a bad idea to put government in charge of promoting the highest virtues. And I think this understanding, which is deeply rooted in the Constitution, should be guiding judges more than an understanding of the highest flourishing for a human being. And not to put too fine a point on it, but maybe Vermeil is talking about someday in the future. But how much of your legal education has revolved around the highest flourishing for a human being in law school? All right. How about before law school? How much has revolved around the highest flourishing for a human being? My guess is not a lot. So anyway, but besides the fact that promoting virtue seems to me contrary to the position of a judge in Madisonian constitutionalism, or in a way, this is a way of making the same point. Who among us has had the kind of training that would fit him or her to be making such decisions? But I think that's not a point separate from Madisonian constitutionalism. It's a point that actually derives from, let's say, Madison's 1785 Memorial and Remonstrance. If you haven't read it lately, I urge you to return to it. It will help you think through the questions raised by Vermeil's common good constitutionalism. a work, needless to say. It's a peculiar feature. I think I already mentioned this about his book on common good constitutionalism, which is purports to define fundamental matrix in which the Constitution was founded. It doesn't so much as mention Madison. You won't even find him in the index.
I'm going to squeeze in another question from our online audience. Someone asked if you could talk about how you think the Constitution does or should deal with the pandemic, sort of outside of the purview of the founders, and to sort of bring this back to the subject of constitutionalism. Perhaps you could contrast it with how you think Adrian Vermeule might conceptualize that. And I ask this in part because my at least one of his popular writings, my sense of Professor Vermeule's perspective is that under common good constitutionalism, one could mandate vaccination because it would be in the public good. And so I suspect that you have you could offer a contrasting view of how the pandemic would be treated under your preferred view as compared to.
You suspect correctly. Would everybody have heard your question? Should I?
Maybe repeat. Sorry that it was so long.
No. Question which initially threw me for a bit of a loop was both what does my approach, what implications does my approach have for dealing with the pandemic, and how would I contrast that to Vermeule's approach? Actually discusses it in the book, and you're absolutely right. Remember, Professor Vermeule is a scholar of the administrative state, and in this book, to my mind, he makes the rather remarkable suggestion that the administrative state, as it exists today, is highly desirable, and it is to be used as a vehicle, a prime vehicle for implementing the common good. It is a source of the promotion of that solidarity and sustainability that we need in constitutional government. And yes, it would seem, well, in various passages, Professor Vermeule suggests that common good constitutionalism respects role morality in politics, meaning it's not a it doesn't grant all political officials at all times the right to overrule rules and regulations on behalf of the common good. But he does suggest that it would have authorized the government to take dramatic steps. My understanding of Madisonian constitutionalism is that we live under a government of limited powers acquired, extended powers over the centuries, but essentially of limited powers, which is, Vermeule deplores this and implies that it's contrary to that fundamental matrix, but I think it's part of the original understanding, certainly the original sensibility, federalists and anti-federalists, to be skeptical of, concerned about the exercise of power because of the tendency to abuse power and worries about centralizing power. So I can't pronounce on issues that didn't come before the Supreme Court. I can't, because I don't have the ability, right, to imagine them. But it seems to me perfectly consistent with constitutional government would have been a view that that recognizes that on many matters, including safety, health, welfare, police powers, the states are in a better position to make determinations that the federal government. That one rule emanating from Washington for the whole country was looked on with skepticism in the 18th century, and that consistent with Madisonian constitutionalism, providing decent latitude for the states to experiment in confronting a once-in-a-generation pandemic would have been a wise thing to do. But now we're talking about matters of prudence. So let me conclude this answer, returning to a point I made earlier. In a way, the book is misleadingly labeled. It's really should be, well, Josh says human good constitutionalism. It should really be combine his suggestion with mine suggestion, human good constitutional theory. It's a lot of passages on the administrative state, but to the extent that he makes an argument that the common good thinking is the fundamental matrix in which the country was founded, it's based on the reading of cases and as I already said, arguments with Ronald Dworkin and the originalists. It's not based on large reflections about American constitutional government, and so. And I say this as a former law student. You could also say, betrays the. You'll forgive me. Doesn't apply to anyone in this room, of course, but the professional deformation that many scholars of law undergo, which is to have a court-centric view of American political life, as if the court is a microcosm of all American politics. So I don't see I didn't answer your question in regard to Supreme Court cases and controversies, but I think offer a constitutionalist argument, which respects our federal system.
I know we're almost out of time, but Lindsay, do you want to ask the last question?
Please. Great.
I was very interested by the Aristotelian reference because of the way that balance factors into the Aristotelian conception of virtue. And to try and smuggle Madison into a conversation about Aristotle, Madison gets a rep for being very concerned with balancing human vice. The government of limited powers is presented to many as being designed to respond to that. So I guess my question is, Madison nevertheless seems to ask quite a lot of virtue from citizens. The Federalist Papers theory building on has described how citizens need to be rational, judges need to be rational, politicians need to be reasoned, and at least somewhat interested in the good of others. A system that's made of absolute equal doesn't function no matter how good its institutions are. So I suppose, is it really true that Madisonian constitutionalism is disinterested in virtue, or is it interested in a different sort of balance that Aristotle might want to achieve, or is it a similar balance?
As you suggested, you already provided plenty of evidence to show us correctly that it would be wrong to say that Madison's not interested in virtue. But I think he's actually, I agree completely that Madison, like Aristotle, is very concerned about balance. But of course, Aristotle teaches us that balance in one regime will differ from balance in another regime. So the question for us is, how do we achieve the right kind of balance in a liberal democracy, a democracy that protects rights? So it should be obvious that it's a wrong inference that the Constitution doesn't care about or doesn't need virtue because it doesn't discuss virtue. More specifically, it's wrong to conclude that the Constitution doesn't care about virtue because it restricts government's ability to promote virtue. The constitutional Madison's perspective assumes institutions outside of government that promote virtue, families, schools, churches, other forms of religious organization. And you can imagine a variety of associations. This is not Madison, but other thinkers, Tocqueville, in which virtue is produced. The case of the system depending on something, certain qualities of mind and character, which it itself doesn't directly produce. No logical incoherence there, and it's a kind of balance. Now, we might reasonably worry, and this is clearly a worry that motivates Vermeule and the others, that the system, although I put it now differently, the system is badly out of whack. Those institutions that Madison could reasonably count on to promote the necessary virtues, not the complete catalog of virtues, not, for example, the virtues that Benjamin Franklin lays out in his autobiography, not the classical Aristotelian virtues, not the Christian virtues, some synthesis of basic virtues, virtues relative to freedom. Our institutions today, we could worry, are not promoting the virtues in which our free society depends. So what then? Well, one answer is, in effect, although it's disguised as a return to the original understanding, classical legal tradition, you might say we need a different kind of regime, a regime that promotes virtue. But here, as you know, I think we really should pay attention to Madison's counsel, that when we are confronting diseases incident to Republican government, we should restrict ourselves to remedies that are consistent with small r Republican government. I should stop there.
So thank you very much, Peter, for that interesting talk, and thanks to the folks off in Zoom land for some good questions, and to everyone here. That was, I think, maybe the most profound of our talks this year. So thank you very much. And I encourage you to be looking ahead to our annual conference. I say annual, except that we couldn't have it for the last several years. And so we have a particularly star-studded conference planned for the weekend of May 20th on the subject of histories of presidential power. And encourage everyone to watch, first of all, to watch for the email notices of that, but also to sort of mark it on your calendars as something that will be of interest. And with that, let's please join me in thanking Peter Berkowitz for that stimulating talk. And maybe we should thank Adrian Vermeule in absentia for making it possible.